This is Bart Peterson, and you are listening to the FCPA Compliance Report on the Compliance Podcast Network.
This is Greg Gilchrist, and you are listening to the FCPA Compliance Report on the Compliance Podcast Network.
This is Dan DeMarco, and you are listening to the FCPA Compliance Report on the Compliance Podcast Network.
The FCPA Compliance Report is the longest-running podcast in compliance, engaging a wide variety of compliance-related guests and topics. Each week, Tom Fox brings you the top commentators and information which will inform your compliance program going forward. Join us again for the top podcast in compliance, hosted by the voice of compliance, Tom Fox. The FCPA Compliance Report is a production of the Compliance Podcast Network.
Hello, everyone. This is Tom Fox. In this episode, I have with me Ephraim Wernick. He is a partner in government investigations and white-collar practice at Vinson & Elkins in Washington, D.C. He joined the firm in June 2019 after serving 11 years as a federal prosecutor, including most recently as the Assistant Chief of the Department of Justice's Criminal Division Fraud Section. Today, we take a deep dive into the weeds on the Hoskins case. We consider the procedural history of the Hoskins case and, most interestingly, the jury instructions. It's a fascinating look at how prosecutors prepare cases and what it means for compliance officers in the real world. Hello, everyone. This is Tom Fox back for another episode. And for all you lawyers out there, you're in for an incredible treat today because we're going to really go into the weeds on one of my favorite topics, jury instructions. For those who have not worked on jury instructions, I cannot tell you what you have missed. The number of hours I spent on jury instructions as a trial lawyer were really beyond belief. But to help us through the jury instructions, and specifically in the Hoskins case, Ephraim Wernick. He is the most recently the Assistant Chief of the DOJ's Criminal Division Fraud Section, where he supervised dozens of FCPA cases. And he's moved over into private practice, landing at Vinson Elkins' Washington, D.C. office. I should also note he's a fellow Texas Longhorn, so hook 'em, and our Alamo Bowl win. So with that incredibly long-winded introduction, first of all, welcome and thank you so much for taking the time to visit with me today.
Well, it's my pleasure, Tom. Thanks for having me.
So this is one of the most fascinating FCPA cases, not simply because it actually went to trial, but it has one of the most unique procedural histories of cases. So I was wondering if you might start, Fry, with talking about the procedural history that got us to trial.
Yeah, it really is. And, as we'll, I'm sure, talk about, this was one of the most watched trials in recent memory. FCPA trials have become more frequently, but still are fairly rare occurrences. And the Hoskins case had a real spotlight on it, but the lead up to it was very interesting. You had it stemmed from the Alstom case, which was a 2014 corporate resolution, one of the largest corporate resolutions still ever, and Alstom being a French company, paying bribes, and there were multiple individuals charged. The most of them, in fact, everyone but Hoskins, ultimately pleaded guilty. And Hoskins was the holdout. He was initially charged as a co-conspirator in the case. And I will say, there was nothing really all too controversial about that, the way it was charged. He was, if you read the FCPA guide that came out in 2012, it was very much understood that charging someone as a co-conspirator liability could extend to foreign nationals in the way it did here. But Hoskins challenged that. The byproduct of having so few trials over the decades that the FCPA has been in place is you haven't had as much litigation and narrowing and refining of the statute as you do with other laws. And so this was aptly challenged by the defense here, and the Second Circuit came down with an opinion. It took quite a bit of time, actually, to issue the opinion. I think over a year lapsed from the time it was argued, from the time the Second Circuit ultimately handed down the opinion, saying that no, Hoskins cannot be charged as a co-conspirator. He was not among the specifically enumerated categories of defendants under the FCPA. But he could be charged as an agent of a domestic concern or within the territorial jurisdictional reach under 15 U.S.C. 78 DD3. So the DD2 or DD3 opportunities were there, and apt here would be the agent of a domestic concern under 15 U.S.C. 78 DD2. And that was ultimately the basis of the FCPA charges against him. He also was charged with money laundering counts, and we'll get to that, which are not subject to the same statutory restrictions. But for the FCPA purpose and for the programmatic purpose of charging FCPA cases by the FCPA unit, that was really significant limitation and changed the way that the case could be tried.
To trial this year, and even after the Second Circuit opinion, there was, I don't want to say controversy, but at least a debate around the specific jury instructions. And the Department of Justice, I couldn't tell from the written record if it was a joint agreed jury instruction or both sides submitted their proposed jury instructions, and the court either selected one or crafted their own instruction. But we concluded with a jury instruction that I'd really like to read, which gave the three elements that the prosecution had to establish. Number one, a manifestation by the principal that the agent will act for it. Number two, the acceptance by the agent of the undertaking. And number three, an understanding between the agent and the principal that the principal will be in control of the undertaking. First of all, did I get that procedural history right, to how we got to that specific instruction? And have there been others, either district courts or circuits which have looked at this issue?
It's a really interesting jury instruction, like you just said. And it's interesting, I think, for one real important reason. Hoskins wasn't the first case to be tried under the theory of an agent of a domestic concern after the Second Circuit opinion. Of course, it's the named Hoskins, so people follow it. But Ho was actually the first one, the Ho case in SDNY in 2018. And I did, if you look at the jury instructions in Ho, which follow a series of jury instructions that are similar to that with agent of a domestic concern case law, I think Lambert also, the language in the instruction is an agent is a person who by express or implicit agreement with another person or entity called the principal undertakes to represent on behalf of the principal in performing the service for the principal. And then it goes on, joint participation in a partnership or joint venture, whether formal or informal, suffices to make each partner or joint venture an agent of the others. A broader understanding of agency, and doesn't really include the control element. And if you actually look at the history of the Ho case, the government very much fought the idea that you had to show control. My understanding was this was an intentional decision by the government in the Hoskins case to actually be open to the idea of control as part of the instruction. And that's significant. This was an area that had a real spotlight on it. And I think a really savvy move on the part of the trial team, if I'm right about that, because it really, you're taking a narrower, more defense-friendly instruction that everyone knows is going to be up on appeal again. And it really tells the Second Circuit, look, we didn't go with a more expansive definition that's been applied in other cases. We actually went with a narrower instruction, one more favorable to the defense. And the jury still agreed with the government that it could show that the principal was in control of the undertaking that Hoskins was doing. And so, look, you had extraordinarily, I will say, I know that the prosecutors involved, and, Dan Kahn, Lorinda Laurier are among the most talented prosecutors out there. And, they have a wealth of experience. They certainly know the FCPA up and down. And I have no doubt that they were able to, really be thoughtful in how they approach this. And, and they're savvy in the way that they can think through this, and also steps ahead. If you get the conviction, they're really trying to put in the best position to preserve that conviction. So, my understanding is that was likely the thought process here, and it's not surprising given what I know about this trial team and their capability.
You really pointed up something I wanted to emphasize, which is the multi-level nature of any decision that you make in trial, starting with your jury charge and then your jury instructions, because you do have to consider, number one, what's going to be the impact if it does go up on appeal. And I think you're absolutely right. We will have an appeal on this one. But also, I'm always fascinated because your jury instructions lead you in many ways to your presentation of the evidence. So it's also with an eye towards the jury, because not only is the jury going to have to read the jury instructions, but you as the prosecutor or even the defense lawyer, if it's your instruction, you have to tie your evidence to that instruction. So in closing, you can say, we were required to show control. Here's how we showed control: 1, 2, 3, 4, 5. And so I was really interested and intrigued, frankly, that, as you said, they were thinking so many steps ahead, the prosecutors in this case. And by having the more narrowly drawn, I think jury instruction was actually tactically a brilliant step, because you're absolutely right. The court, any appellate court, will look at this in that light, particularly with the facts now that they have tied to, that the jury found, not the facts presented, but the facts the jury found, which tied to the issue of control.
Well, they must. First of all, Tom, you know as well as anyone, and you're exactly right. I mean, the jury instructions, that's the roadmap, and it's you have to tie the evidence to those instructions, and so you're thinking through that from the time you charge the case through the time you are putting on the evidence and asking, eliciting testimony from the witnesses, putting in the documents, always with a mind of how do I bring that back to the elements that the jury's going to be charged to consider, and so. All I can think is, number one, you have a skeptical Second Circuit who's already weighed in on this, and so the trial team here must have very good comfort that they can get to the control element here, and that they'd be able to put in the testimony and the documents to really prove that up. And I wasn't at the trial here, but I think, like I said, they don't make that decision to go in that direction if they're not confident they can prove that element at trial. And clearly the jury agreed. It took less than a day, or about a day, to return a verdict on a fairly lengthy FCPA trial. So again, kudos to the team there for being able to execute it in the way they did.
So the evidence that was presented in trial, and neither one of us were present, we have both read some summaries, but the thing that intrigued me was that the evidence actually followed in many ways what happens in reality in a corporation. There can be a legal structure set up in an organizational chart, but in many ways it's the informal structure in a company which dictates how it's run. And so that you can have a U.S. subsidiary actually in control of a foreign national outside of the United States, directing a specific business process or business transaction that may not seem self-evident initially by reviewing a corporate structure. And it seemed to me that the prosecution was able to present factual evidence, which the jury accepted. Control was present.
Yeah, it was. I agree. Look, I didn't sit on the trial, and I have had work to do, so I have not been reading through the transcripts. But but based on the public reporting, that seems to be right. I mean, look, what we do know is that Hoskins was the executive at the French parent company, never stepped foot in the United States, and was charged, though, with being the agent of the U.S. subsidiary. And as you said, it's not self-evident that could be the case. But you're right. I mean, companies operate more fluidly than that. And certainly, what I understand came out at trial was multiple witnesses talking about how they relied on Hoskins for support to execute the scheme, the bribery scheme in Indonesia that was charged. This was a difficult case for the government. You had to not only show the agency aspect of this, but taking another step back, and this goes away from the jury instructions, but really much more to a jury appeal. You have a person that's never stepped foot in the United States, and he's being charged in a U.S. courtroom with a fairly obscure statute. And how do you get the jury to care about that? That's always one of the biggest, most difficult things as a prosecutor bringing these cases. How do you get a jury to care about what some foreigner was doing in a faraway, distant land? And why are they hearing about it in a U.S. courtroom? And, this isn't something that you're trained on. You are trained on. This isn't something that really gets as much attention as it deserves. It is that's where you kind of separate the cream from the chaff here, and you've got a really effective presentation at trial to get the jury to care about that piece of it. Again, separate and apart from the rest of it. Now, getting back to the agency piece and the instructions, You have evidence. What I understand is, he approved the scheme, but that doesn't necessarily go to agency. But the support feature does, and perhaps there was documentation and other testimony that we didn't read about that will also go in and support this as well, to meet that element that the government had to show.
If I could turn now to a little bit different focus, because I was very intrigued at the ACI National Conference. Assistant Attorney General Brian Benczkowski talked about this case, and he talked about the way the Department of Justice would analyze the agency and, more importantly, the control question going forward. And one of the key elements I drew from his talk was that this will be an incredibly fact-specific analysis for each case, and that each case will stand on its own facts, and certainly the department will do its own analysis. It will be open to other analysis or counter arguments by defense counsel on these points, but that there will be sort of no one agency fits all for foreign subsidiaries or U.S. subsidiaries of foreign companies. Would that be a fair assessment of Assistant Attorney General Benczkowski's remarks?
I think that's right. I also don't think it's a sea change from how the FCPA unit always handled these things. You're going to take them on a case-by-case basis and try to see whether or not the facts will meet an agency theory. Notably, if you look at how the cases have been charged since the Second Circuit came down with Hoskins, you did see an intentional effort to charge agency theories of liability, at worst as an alternative theory, to make sure that you could meet the stricter requirements. That wasn't done willy-nilly. That was done because you took first to look at the evidence and said, well, yes, you can show agency. So, what is interesting is with the new Hoskins jury instructions, it is likely to be that those will be the new norm. And so you do have to look at those three elements we discussed and say, can we show those elements to meet that agent definition? And before Hoskins, I think people were looking at Ho as whether you can meet those elements. So you do have a bit of a higher bar, practically speaking, but it's not one that's in any way insurmountable. And I don't disagree with the AAG here that the government is going to take this on a case-by-case basis.
Do you see this decision, or the verdict, and trial court's decision to date as opening up perhaps wider prosecutions, or do you think we'll need some additional clarification and then add on the case-by-case analysis that you just talked about?
Well, I think people will be eagerly awaiting the Second Circuit's revisiting of this question on appeal. Whether they are comfortable with the instructions as they were and with the evidence, that there was sufficient evidence to meet those elements. And if so, then I think you can certainly expect to see continued prosecutions of foreign nationals in this way. Had the jury reached a different conclusion here, that could certainly have changed the approach of the government to take perhaps a more modest or narrower approach to how to bring these cases. That being said, the reality is foreign nationals in these FCPA type of cases almost always can be charged with money laundering, wire fraud, and other counts that aren't limited the way the FCPA is in the Second Circuit. And so whether a criminal defendant, a foreign national defendant, will be charged with FCPA might be one thing, but they could certainly still be charged with money laundering, even with an FCPA, SUA, underlying conduct being the FCPA violation, and wire fraud as well. These are always, these schemes by their very nature are concealed in how the money is moved. They're international. So, the International Promotional Money Laundering Statute, 18 U.S.C. 1956 A2A, the conspiracy to commit money laundering, and 1956 and 1957 are fertile ground for bringing cases against foreign nationals like this, irrespective of the ability to bring the FCPA case. But your point is, should we expect further tailoring by the Second Circuit, and how is the government going to move forward? I don't think we'll see. I don't think we're going to see an expansion beyond what's happening now. But it has been a fairly expansive use of the FCPA thus far, and at least at this stage, is one supported by the law and the evidence.
For those who may not understand the appellate process, Fry, I was wondering if you could give a few words about how internally that works in the Justice Department. Is there an appellate section? If there is an appeal of this case, will it go to that section? Will drafts be largely written by the fraud unit or the FCPA unit, I should say? Could you just give a few words on how that process might work?
There is an appellate section within the Department of Justice, and that section oftentimes will take the appeals themselves. In a case like this, there's no doubt the fraud section trial attorneys are going to be heavily involved. First of all, they're all very capable at briefing themselves. It's not to say that they'll argue the case in the Second Circuit, though they could. We also have the dynamic, of course, that you team up with U.S. attorneys' offices, each of whom also have their own appellate section. And U.S. attorneys' offices differ as to who handles the appeals. SDNY is one that is well known for the fact that their trial attorneys frequently will argue their very same cases on the Second Circuit. I came from an office in the U.S. Attorney's Office in D.C., where you typically handed those off. And when you handled appeals, it wasn't necessarily your case, although it could be. So there is some flexibility in the approach. My hunch is that the fraud section and appellate section would be very engaged together in this particular case in responding to the appeal, and most likely someone from the appellate section would argue this one. But it could very well be a fraud section attorney, if they wanted to, could do that as well. That certainly happened in the past. Or the AUSA here should not neglect to mention Dan Novick, who also tried the case.
So, Fry, unfortunately, we're near the end of our time, but this has been a fascinating exploration, literally into the weeds of jury instructions in the Hoskins case. But it also, I hope, illustrates for me the greater point that jury instructions and charging documents are really the foundation of everything that happens thereafter. So thank you so much for taking the time to visit with me, and I look forward to continuing the conversation.
No, my pleasure. Thanks for having me.
This is Tom Fox again. I'd like to thank you for listening to this episode of the FCPA Compliance Report. The FCPA Compliance Report appears weekly on Monday of each week. The FCPA Compliance Report is a production of the Compliance Podcast Network and a proud member of C-Suite Radio. Thanks again for listening, and I hope you'll join me again next week on the FCPA Compliance Report.